under copyright law, timing is so important. And we're going to talk about you getting your copyright registrations and why that matters so much. The Supreme Court essentially just blew up copyright law. And for those of you who maybe have copyright claims, you might be dealing with this at some point in the future. This is going to be very, very beneficial for you. I am a copyright attorney and I've done entertainment law for almost 10 years. I definitely specialize in music, but in the general realm of what I do right now, I have a very complicated federal copyright case. And all the stuff we're going to be talking about today comes up with these types of things. So what I'm going to try to do is interweave just some examples of things that I've even dealt with, but also give you the update on what's going on. So if you guys are excited, get your gavels. We're not quite ready to use it, but you can at least like the video and and let's keep going. All right, so the Supreme Court of the United States came down with a very big decision, May 9th, 2024. And I want to start with just telling you what happened. Okay, so let's just read through this little synopsis. So this dispute started, and I love how the court puts this. This dispute had its start in a decades-old, short-lived music venture. In 1983, Sherman Nealy and Tony Butler, they formed Music Specialists Incorporated, and they did a total of one album and then a couple singles. So what's amazing to me about this story I'm about to tell and the fact that all this has now changed copyright law and improved things for claimants and all that was based on this very short-lived collaboration of one album and a bunch of singles. Okay, so the company, so meaning Music Specialists, which was their little collaboration entity, their company recorded one album, several singles. The collaboration dissolved a few years later, and Nealy soon afterwards went to prison for drug-related offenses. He served one prison term, which was from 89 to 2008. What is that? 19 years? And another from 12 to 15, so another 3 years. Meanwhile, prior partner, unbeknownst to Nealy, entered into an agreement with Warner Chappell Music to license work from their little project. Now, the one thing that they did right is that they, formed an actual entity, and a lot of people don't do that, right? We do collaborative things together and we just kind of do it. We don't even sign contracts half of the time, which is a big no-no. At an absolute minimum, you want to make sure that stuff is just documented, and the clearest, best way to do that is to have a contract. But it doesn't happen in all situations. So in this case, they actually had formed a company together, which was this Music Specialist, did the thing, and then the music was signed, right, to Warner Chappell. In my line of work, this stuff happens so very frequently. And the thing that gets missed is that when two people work together, there's joint authorship. And it's kind of like the intention, right? So if you and I are working together and you and I are intending that our separate ideas are going to be put into, let's say, the album, the song, then even though we do have separate ideas, and maybe you're like, you're the person that came up with all the lyrics and the melodies, and I'm the person that did all the music production, I came up with the instrumental, even though we had like super separate stuff that we contributed, it becomes one conglomerate that under copyright law is recognized as one thing. So then when one partner runs off and does something with that thing, the other partner now has claims. One of the things that's tough and that I've dealt with is that, I've had people who've written books together, and then one person's like, it was really supposed to be like my project. It was really my idea. And this other person was just being nice and helping and all this stuff, but it doesn't change. Then now you're kind of locked into, a marriage, so to speak, with that person. And you guys have to agree on stuff. One person is not allowed to just to run off and sign stuff to Warner Chappell. All right. So one Music Specialist, so this is their company, and one of their songs, Jam the Box, or one of the works was called Jam the Box, was interpolated, okay, into Flo Rida's hit song. For those of you not familiar with interpolation, it's where a direct sample of the song is not necessarily used. There's some element of the song that is adapted. So we saw that with, what's the song, Milkshake by Khalees, which was interpolated into a Beyonce song. Anyway, so it was the In the Air, which was the Flo Rida hit, which sold millions of copies. It reached number 9 on Billboard. Use of that song was in turn licensed to several TV shows, very popular. So You Think You Can Dance. I actually had a license on So You Think You Can Dance. It was a great moment. Other Music Specialist songs found their way into recordings by the Black Eyed Peas, Kid Sister. In 2018, following the second prison stint, Nealy sued Warner Chappell for copyright infringement. Nealy alleged that he held copyrights to Music Specialist songs and that Warner Chappell's licensing activities infringed his rights. The infringing activity, Nealy claimed, dated back to 2008. So 10 years before he brought the suit. Nealy sought damages and profits for the alleged misconduct. When you guys have claims and you go, here's a situation, and we'll even use, because I literally had very similar issues to this with joint authorship issues. And one of them, it was a band situation, and bandmates all contributed to the thing. There was like two main people who were kind of in charge with the music creation. Everyone else just kind of played the shows, right? So really it was just two people. One of the people went and took the music and distributed it and, was like supposed to be in charge of things and all that. And they just tried this little project. And the person who ended up distributing the music was like, telling everyone else, oh, it flopped and no streams, no money made. And then it like caused the person I was working with just to become like extremely devastated, to quit music and never thought about it again, didn't check music platforms, anything like that. Unbeknownst to this person, the other person was not being truthful. And actually, the music did extremely well. And, because there was no like social media, and this was like obviously a while ago, there was just no knowledge about this. And so this music was being streamed in the millions and millions. And so this one person just connected, the bank account to the distributor and just collected the money for a very long time, and in fact remained friends through the whole thing. This is not even the only time this has happened. I've literally had cases like this before. So in any case, stuff happens. And so in Nealy's case, he's like, hey, I was dealing with some other stuff, and the infringement that I'm alleging here happened a long time ago. And the reason why this matters is because under copyright law, timing is so important. And we're going to talk about you getting your copyright registrations and why that matters so much. But in any case, let's continue. Become your own record label, which is literally if you're like, hey, I want to start a record label. Cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make six figures from your music career and you want to do this for real, like I'm going to give you what you need. Okay, so for his claims to proceed, Nealy had to show that his claims were timely. Well, why do we care about that? Under the Copyright Act, a plaintiff must file suit, they must file their lawsuit within 3 years after the claim accrued. Well, wasn't he complaining about the thing being 10 years ago? So what's this 3 years that they're talking about? On one understanding of that limitation provision, a copyright claim accrues when an infringing act occurs. Again, pursuant to this case that they cite, didn't it occur 10 years ago? So a plaintiff can complain about infringements going back only 3 years from the time that that person files a lawsuit. If that rule governed, many of Nealy's claims would be untimely because they alleged infringement occurring as much as 10 years before. But under an alternative view of the Act's limitations, a claim accrues when the plaintiff discovers or with due diligence should have discovered the infringement. So going back to kind of my little, case example, I go, all right, so friend goes and distributes the music, and there was knowledge that this person was going to do this thing in the beginning, but it was represented that it all failed and like everything came down, there was no money, it was all a big flop, and everyone's big losers, right? And so the question would be in our little case study of, well, does the person, right, who's now claiming copyright infringement, like, dude, you've been distributing the music for all this time and collecting all the money, but didn't find out about it till way, 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 way later, pursuant to applicable law, they're saying, well, you have a 3-year thing. It's like 3 years, you can't go back to that. So the discovery rule matters. And so the court here is talking about, well, there's this other rule that maybe we can apply, which is through due diligence, should someone have discovered it? So in the case that I just gave you, and drop a comment, let me know what you think. Do you think it's reasonable that if someone's not, they don't have really social media, they're not on social media, they're not checking music platforms because they kind of gave up on their music career, is it reasonable to say that they would not have discovered the infringement? Because now we have this little door to get through of, well, maybe we can get beyond the 3 years, but let's see what the court has to say. That so-called discovery rule used in the circuit where Nealy sued enabled a diligent plaintiff to raise claims about every or even very old infringements if he discovered them within the prior 3 years. Nealy urged that all his claims were timely under the rule because he did not learn of Warner Chappell's infringement conduct until 2016. Just after he got out of prison and less than 3 years before he sued. In the district court, Nealy ran into a different timing objection related to his ability to bring suit, but this one was in regards to recovery of damages. So Warner Chappell accepted that the discovery rule governs the timeliness of Nealy's claim. So meaning when he discovered, he had to bring the claim, he had to file a lawsuit within 3 years. Did he do that? The answer is yes. But, and it argued that even if Nealy could sue under the rule for infringements going back 10 years, he could recover. Because he's just saying, hey, I want to get paid for all the money that you've been making and all the damage that has occurred more than the 3 years ago. Okay. The district court agreed, relying on a decision from the Second Circuit. The court held that even when claims for old infringements are timely, monetary relief is limited to the prior 3 years. So here's what happened. Basically, the Supreme Court, and this is what the Supreme Court does, right? Because there's like, just so you guys know how it works with courts, is that there's like the trial court, right? So there's this court, and then there's a ruling. Then you can take it up to appeal. And you go, hey, we want you to reverse this decision. Either this court says we agree with this court, or we don't, right? And we reverse. And then sometimes you can go above this court with the appeals all the way up to the Supreme Court. So what happened is that we have two different courts who had made decisions. And in one circuit, they say, well, it's cool. You can go back further than the 3 years and go back all the way to the beginning of the infringement. And then in this court, of which Nealy is in, he's like, in this circuit, it says I can only go back 3 years. And we'll talk about this further, but when you think about, you have someone who just didn't know. Well, how does that possibly affect things? Well, let's talk about how it affected Nealy. All right, so Nealy, they're saying he could bring the claims for the infringement for the stuff that occurred within that 3 years, but he couldn't recover any money before all that happened. So appreciating the impact of that rule, the Supreme Court decided to review this case. Okay. So the Court of Appeals, and this is kind of what I was just saying, the 11th Circuit reversed, rejecting the notion of a 3-year damages bar on a timely claim. The court assumed, quote, assumed for the purposes of answering the certified question that all of Nealy's claims were timely under the discovery rule. And on that assumption, the court ruled he could recover full damages. So I am in the Ninth Circuit, just so you know. Aligning itself with the Ninth Circuit rather than the second, the court held that a plaintiff with a timely claim under the discovery rule may obtain retrospective relief for an infringement, even if it occurred more than 3 years before the lawsuit was filed. So guys, I mean, that is huge, not just for Nealy, but in our little case study. Your friend lied to you for many, 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 many years. And now you want to seek copyright infringement claims because that person didn't have permission to distribute the music, because under copyright law, you have certain exclusive rights, which includes the right to copy stuff that you made, to distribute it. And when you're joint authors with someone, they can't go and use the actual thing or create things based on the thing that you made with them, which are called derivative works. And so this just gives us the ability of, hopefully you've exercised reasonable due diligence, which, again, the question of, is it reasonable that you never went on Spotify just to see, like, maybe your music was up? And in fact, just so you know, this particular person only discovered it all this time later because a mutual friend just casually made a reference like, hey, I saw your thing on Spotify. It has millions of plays on it. And that's how the discovery occurred. In any case, for, everyone curious about state of copyright law, there's one big, very big thing that you need to know and keep in mind in regards to your copyright claims. And that has to do with your copyright registrations themselves. Under US copyright law, when you make a creative thing and you put your great ideas into a tangible medium, which is required, right? That authorship, that you yourself, a real human, makes a thing, you got to put it into a tangible medium. So as soon as you record the quick demo on your computer, you have copyright in your song. And that's great about copyright law, right? You don't even have to do anything. You don't have to register anything. And, these like scammy websites that are like, under copyright law, you automatically own your copyright and we can protect you by registering your stuff on our websites, which is dumb. The reason why we want you to actually go and get a piece of paper from the federal government is not because you don't already have copyright. You do. But you want to go and actually register with the Copyright Office because it gives you additional rights that you don't get in the instance that you have to sue someone. Okay. And here's the two biggies. Well, three. Number one, you can't sue someone until you have an actual piece of paper, copyright registration. Number 2, you're not going to be able to get your attorney's fees if you don't have the piece of paper before the infringement happens. And the timing on this is just so unbelievably important that I'm going to pull this up and we're going to take a peek at it together. So under the Copyright Act, which is 17 USC 412. Basically, it goes, you will not be able to get statutory damages, which I'm going to talk about in a sec, or your attorney's fees, okay, if you have a copyright infringement claim, for any infringement of copyright that commences after first publication of the work and before the effective date of registration, unless such registration is made within 3 months after publication of the work. I swear to God, I've had to read that, like, when I was first learning this. I had to read that so many times, like, what the hell are you talking about? What they're basically saying is that you have to have the registration before the infringement happens for statutory damage and attorney's fees. So I'm going to clarify this because it's really important. You can go and get your copyright registration anytime, and you can sue, and you can bring claims all day long. Because you can always get actual damages, which is going to be, you literally took my big Miss Crystal hit song Monster, and I'm pissed about it. And you re-released it as yourself. And I go, I'm going to go and get the profits that you made because you took my song and you didn't pay me for it. Or you put it in your film and you didn't pay me for it. Those are my actual damages, and I can get that anytime by just making sure I have my registration, which I can get even if I don't have it right now. I can get it, and then I sue you, and then I'm like, I want all the money that you made. That process is always going to be able to happen. So that's great. But what we're talking about here is your ability to get your attorney's fees is a really big part of this, because if you are suing someone, attorneys are not cheap. It's a very long process. Any litigation, copyright infringement or otherwise, these things can literally take years, and it can be $100,000. It can be $1 million. Like, it can just be outrageous with the attorney's fees because of how much time and effort that has to go into this. And so it's important that, at the end of this long road, that you would be able to get your attorney's fees. So Kat Von D, she was being sued by a photographer because she did a tattoo. The tattoo looked exactly like the picture. So the photographer's like, copyright infringement. It was a very famous picture of Miles Davis. And so she had to go through this whole case and defend and all this stuff, and she ended up winning. And it's really important that, when you get to the ends of these things and you've spent $100,000 on your attorney fees, that you can recover those, okay? So anyway, you have to get the registration according to section 412. You have to get the registration before the infringement occurs in order to get those attorney's fees. But then the other piece, and this is my number 3, right? The other piece are statutory damages. And so statutory damages, this is huge. Because remember, I was like, we can go after the actual damages, okay? So we can go after the real amount of money that they made on Monster, or pursuant to copyright law, there's statutory damages of up to $150,000 per infringement if it was willful. If someone knowingly took Monster, they're like, this is a great song, I love it, thank you so much. They meant to take it, they meant to infringe my copyright and all this stuff. So it's a huge deal, because it could be the difference of someone making $500 in streaming, or if it's $150,000 per infringement, our claims can be in the millions of dollars. So I really stress that as part of this whole conversation, just to reinforce that you guys really need to make sure that you are registering your copyrights. And kind of my rule of thumb is try to do it within a month of releasing your song. And if you're watching this, like, oh my gosh, I haven't registered my copyrights, and you're like freaking out, it's okay. Take a beat, go and do it. Do it for the songs that you have out. It's really, it's just important. As of right now, the filing fee is $65 with the Copyright Office. You can do it, collectively, like as an album, if it was an album, if it was an EP. It's a little bit of an investment. I get it. But instead of the poor man's copyright, which is a myth of like sending yourself stuff in the mail to prove when you made it, or these websites again that I'm just so outraged by, who are like, upload your stuff to our website and we'll give you an official certificate PDF showing and proving the date of creation. Not a thing. The proof and the requirement is that you get a piece of paper from the federal government. So that's what you're going to do. So recap, current state of the law. You have from the time of discovery 3 years as a statute of limitations, meaning you get blocked off. If you don't do it quick enough, you get blocked off. So you have 3 years to actually file your lawsuit. But according to the Supreme Court, you now have the ability to go all the way back for purposes of your damages calculation to when it first started, which might make a huge difference for some of you, and including Nealy in this particular case. And you're also going to keep in mind in regards to your copyrights, you're going to get your registrations and you're going to do it quickly. You can even get copyright registrations before you release your music. And you're going to make sure to do this because it has a huge impact on your ability to like actually enforce your copyright, your ability to get statutory damages, your ability to get your attorney's fees. And because you are not a hobbyist musician or producer or artist, and you're trying to actually take yourself seriously, that you will register your stuff as just part of your process. When music comes out, guess what? You have to market it. Guess what? You have to make sure that everything is set up and you do all the stuff as if you are your own label, but that includes getting your copyright registrations. Drop your questions down below. I hope you found this helpful. Make sure you subscribe for more videos on all things copyright, music business. I got you covered. We'll see you on the next one.